Welcome back, everyone. I'm delighted to be about to start our third panel here. I'd encourage everybody to come back in. This is going to be a blockbuster panel, as they say. It gives me great pleasure to actually be moderating today's panel. I have the distinct privilege of being on a panel with legal giants in India here. And I'll begin my introductions in just a moment as people begin to come in. In the middle here of the panel is Professor Madhava Menon, who needs no introduction, generally considered the godfather of Indian legal education, having both been an academic at Delhi University Law Center and a distinguished academic, but then proceeding to create and to run the National Law School Bangalore, and then NALSAR in Hyderabad, and then NUJS in Calcutta, as well as the National Judicial Academy. I could continue on with his list of accomplishments, but then we would have no time to hear him speak. To his immediate left is Mr. Gopal Subramaniam, another person who needs no introduction, one of India's best-known senior advocates, also former Solicitor General of India, former That's right. And he's also a former chair of the Bar Council of India, also one of India's best-known arbitrators, and recently become a bencher at Gray's Inn in London. I believe the only Indian actually occupying that position. And then
I need to dedicate it in all fairness to my teacher, Professor Menon, who is here, because I think no student actually gains anything without reference to a teacher. So if there is any word in the honor, I think it's only fair that Professor Menon, who was my mentor and teacher, actually gets full credit for it. Please give him an applause.
Thank you, Mr. Subramaniam. And to my immediate left is Director Shashikala Gurpur of the Symbiosis Law School in Pune, who is running one of India's best-known and most highly acknowledged law schools. Today we have a panel that is going to address issues of regulation and change in Indian legal education. And I'm delighted to be able to begin this by asking our distinguished panelists, starting with Professor Menon, what he thinks are the strengths and weaknesses of our current legal education system in India. Professor Menon.
Well, thank you. Before I say something on the regulatory system and its strengths and weaknesses, let me inform you that I have sought the permission of the moderator to leave the session in between. I have to catch a flight in the evening. So by 3:30 you will allow me to leave. Well, there are multiple regulators in Indian legal education, and some of them are at the federal level and some of them at the state level. At the federal level, as you know, we have the three major regulators: one, the Bar Council of India; second, the University Grants Commission; and third, the National Assessment and Accreditation Council, which is an affiliate of the University Grants Commission. But more importantly, for most of the law schools, the main regulator of legal education is the Bar Council of India, which under Section 7(1) of the Advocates Act, it is the function of the Bar Council to lay down standards of legal education and to recognize universities whose degrees in law shall be a qualification for enrollment for that purpose, and for that purpose to visit the various law colleges, inspect them, and accredit them. This function is elaborated in Section 49(1) of the Advocates Act, which says BCI is empowered to make rules for discharging its functions, which includes the minimum qualification required for admission to LLB, prior to LLB, with what eligibility. That determination function is also with Bar Council of India. The conditions under which an advocate shall have the right to practice, and the standards of legal education to be observed by the universities. So these two sections of the Indian Advocates Act gives the Bar Council of India almost complete authority to prescribe the type of infrastructure, the size of the classroom, the number of students you can admit, the eligibility for those students to study law, then the attendance requirement. So many things they have prepared the rules, a bulky set of rules have been prescribed, including the dress code and whatnot. So therefore, the ills of legal education that you see today, much of it will have to be wound up by the Bar Council of India. To discharge such vast powers over such a large number of law schools in India, BCI has neither the infrastructure, nor the expertise, nor the financial resources. In fact, they collect money from the law colleges to inspect them and punish them. It measures the good, bad, and indifferent institutions with the same tools. Its membership is all legal practitioners who are busy in their own, in different places. They occasionally meet in Delhi and decide on inspection and consideration of the report and laying down standards. Very unsatisfactory state. We had a brief spell when, as Solicitor General of India, our good friend Gopal Subramaniam became the chairman of the Bar Council of India, and during that period a lot of reforms were attempted, partly implemented, but before that he left the Bar Council and it is back to square one. I don't have much to say about it. I am now out of this persecution of the Bar Council. Colleges have many complaints, including downright corruption. The second is the UGC, which has a marginal role in regulating legal education, but particularly in postgraduate legal education, faculty development, and providing funding support. UGC has a major role to play. Disbanding the UGC by the new Higher Education Commission is unlikely to make any difference, excepting perhaps in the matter of autonomy. Any institution that is going to replace the UGC, I believe, will be giving more autonomy to more higher education institutions. That's bound to happen. Majority of the law colleges in India, as you know, are privately managed. They don't care for the UGC grant or any other government grant. In fact, about 65% of law colleges in India are privately managed, privately funded. For them, the regulations are mainly that of the BCI and not of the, and particularly state governments also. Regarding NAC, I don't want to say much. It has started assessment and accreditation of the law schools in India. It has a potential to promote academic excellence in universities, because if it is going to adopt better objective standards for assessing law colleges in terms of the peculiar requirements of legal studies, I am sure that this NAC program of assessment and accreditation will promote at least those bright stars and superstars in the legal education scenario to do better and become world class. Some time ago, when Rajkumar, myself and few others met to discuss about this in the city of Gangtok, there was a declaration, the Gangtok Declaration, which said that we need an association of law schools which have the potential to improve the quality of legal education, and its membership shall be restricted unless it fulfills certain basic requirements. You shall not come in. And that association of law schools can perhaps help build and perhaps handhold some of the other law colleges, improve the quality of the faculty, and provide better study materials, and help improve more and more law colleges to come up. So I believe that perhaps an association of Indian law schools, similar to the American Association of Law Schools, and perhaps an Indian Council of Legal Research to be able to fund and identify the potential of institutions teaching law, to develop research capabilities. These two institutional reform, along with the Higher Education Commission, will help strengthen the existing standards in legal education. One more thing, I understand that a national education policy is on the anvil. it may come any day. And that has a full chapter on legal education. If and when that is accepted by the Government of India, naturally the Bar Council or whomsoever the regulator will have to reflect the norms and standards and procedures prescribed by the national policy in respect of legal education regulation as well. So there are occasions which are coming up which might make a change in the regulatory scenario in India for the better. Thank you.
Thank you, Professor Menon. Mr. Subramaniam, you as former Bar Council president, but also as one of the key authors of a very substantial report from 2009, would also have, I think, some very deep insights on the current strengths and weaknesses. We'd love to get your thoughts.
First, I think Professor Menon is completely justified in saying that the Bar Council has failed to fulfill, shall we say, the statutory mandate and possibly the trust reposed in it. I think it is completely preposterous that you have over 800 or 900 law colleges with very little quality and very little assessment, and the basis for granting recognition, I'm afraid, is completely faulty. My own opinion has been that in any particular economy, even if it is a free market economy and even if it is guided by principles of access to justice, there has to be some sort of a control over the number of colleges, the number of students, the quality of admission, and what would be the real output from those universities so that they make an effective impact on society. So I do completely concur with Professor Menon's criticism that in terms of criteria, and the criteria are well formulated. I must tell you, it's not that criteria are absent. We have actually seen the best of universities. We have seen the best of amphitheaters in any modern, shall we say, law college. We have seen what are the acoustics, what kind of curricula can in fact be imparted. We've also seen how wonderful could online education or cross-distance platforms in fact undertake and revolutionize, and I really thought that this all could happen, and I think we were getting there, almost ready to happen. But I think the vested interests are so much that when I brought about the subject of merger, that don't have 900, please make them 120. And I'm not saying extinguish the present ones. Please bring them on quality parameters so that you don't lose out. But at the same time, you must be willing to bring it on quality parameters. And I think that really was a bit of a turf war. And vested interests do prevail, I'm afraid, in the matter of grant of recognition. In fact, one of the judges of the Madras High Court very recently told me that he had written a judgment about some sort of completely a whole host of colleges which can be called as dummy colleges, where degrees are being given, and he struck it down and he said that this should be completely undone. Now, unfortunately, the matter is up in appeal in the Supreme Court, and a stay of his judgment has been granted. So we have problems here, but I think what we should look at is possible solutions. Is it that do we not have solutions? We have them. What are they? First, I think we have to be modern. We have to be scientific. Just look at the people who are here. We have Dean Wilkins, you have Dr. Testy, you've got Raj Kumar, you've got Professor Menon. Just let's put four of them together and four of their ideas and the way they have looked at legal education and how do they think about legal education. I've actually been following their work over a period of time. If you see how Dean Wilkins has looked at it, he has looked at it in the sense, now take the way he has analyzed the Brazilian economy. How has economic development in Brazil led to greater educational development, particularly in the legal education sector? He has looked at what happens in China. He has looked at what happens and can happen in India. And I think it's a very important point which we must consider. He is willing to come forward with ideas of, shall we say, the standards of modern neutral accreditation, which can be international in character. Now, I want to demonstrate that what Dean Wilkins actually speaks about can be practiced. I conducted an examination to qualify lawyers. I must tell you that a lot of lawyers didn't like it. And one of them happened to also be an alumnus from Harvard. And it was 2 years later I realized that this chubby boy was actually, he's the same boy who protested against the exam when I went to wish them luck. And he was one of my brightest juniors. So, but then, it's a good thing to protest, but I think they all took it well. But that was an international quality exam. I had international inspectors to come and look at the exam. As I talked to Dean Testy, that there were psychometric inputs into the exam, and it was an OMR exam. So actually I received no complaint from not a single student about any unfair marking. And we did trial runs of the exam on the website so that nobody was actually taken by surprise. Now look at what Professor Menon did. Now take number 2, him. This whole idea of case law method of teaching, very few people know was actually his contribution. Very few will actually acknowledge it. Many others have taken credit. But he was the one who said that let's have small, digestible modules capable of assimilation by students. He's the first one who believed that there should be cross-fertilization of different disciplines. A lawyer just can't be purely a lawyer without having regard to society. So he actually is the first person who balanced, shall we say, the aspirations of young men that when they are lawyers, they are financially independent with, shall we say, social commitment towards society, including legal aid. I think that was a brilliant balance which he struck. And I'm sorry to say that today, what I do see, while I see the most extraordinary, brilliant sparks flying around, is that their commitment to legal aid, and particularly trial court work, is on the decline. I say this also in a context. Now I come to Raj, and why that context is important is, and I discussed it with him, we must understand that our society, the Indian society, the rule of law is under siege. If somebody says that rule of law is not under siege, he's kidding you. Is the legal profession under siege? Yes. Actually, today, lawyers, many people in authority would like them to be dispensed with. Many people would like judges themselves, if possible, to be dispensed with. Otherwise, they would like dispensable judges. Now, it's one of the two. Now, I think that's a very serious situation. At this moment, the need of the hour is to have the strongest legal profession with the strongest moral metal, which is why what Raj does is he has actually placed a lot of emphasis on ethics. I just wish to share on a lighter note. I'm sure Dean Testy will find it absolutely amusing. I actually printed out a new code of ethics when I was chairman of the Bar Council. It needs to be countersigned by the Supreme Court of India. It was passed by the Bar Council of India. It's still not been signed off by the Supreme Court. And I incorporated the best values of the American Bar Association, the Australian Bar Association, the Law Society of UK, and made it all as principles in the Indian Code of Ethics. Now, I personally think that unless and until ethics are taught to a lawyer, he can't take important decisions vis-a-vis a client, for a client, and in a court of law. And I think this is very necessary, that ethics is absolutely a foundation. Now, therefore, the Bar Council was supposed to be the custodian of first prescription of standards. It prescribed it, but failed to implement it. It is the one which has prescribed the Code of Ethics, but it actually doesn't enforce the Code of Ethics sufficiently. I come to Dean Testy and her contribution. What she did was jurisprudentially somewhat fascinating. She merged, shall I say, a theory of intrusion, of fundamental rights of women, of gender equality, in a field of what we call as masculine arrogance, called the corporate power. But she did it structurally, I think, brilliantly. But that's a possibility of fusion. So what we need here at this moment is the possibility of fusion. When you look at these three entities, now let's look at one. I've already said enough about the BCI. The UGC is the University Grants Commission. I look at it with great deal of empathy because I see it only writing letters to the Ministry of Human Resource Development, and the Ministry of Human Resource Development treats it as an undergrants commission and not a university grants commission. So what we are left with is with NAC, which is actually a fledgling and which is not even, it is not really a robust baby. But is there an answer? There is an answer. The answer is one, I think at this moment, what Professor Menon, I think, said somewhat far-sightedly, and I think the thought should be taken further by the House, which is self-affirmation and a self-declaration, like what he called as the Gangtok Declaration. It should be a very strongly worded declaration where universities or colleges which impart legal education must actually ensure certain basic standards of governance, basic standards of recruitment of faculty, and research. Research should be encouraged. You must know the figures in India. They are actually wonderful. You've got 760 universities according to one author, 864 according to another author. You have 38,498 colleges according to one, 40,026 according to another, 31.56 million students are undergraduates, 80% are undergraduates, and only 0.67% are interested in research. So when I passed a resolution that they must get UGC pay scale standards, that is the law professors and teachers, no institution actually implemented it. They just didn't want proper teachers. So if you are not going to encourage teachers, and if teachers are not going to be given the respect, and there is something which we must understand, that this profession is, and again, we have some wonderful people from your delegation who talk about the interface between law and technology. While law and technology is a brilliant interface, it actually simplifies, shall I say, the delivery of resources in a fantastic manner. It's almost, you are touching a Harvard professor through a screen and he smiles at you, even though he may not be addressing you, but you get that same feeling. And it's so nice to see Washington School of Law, Dean Testey's institution, having put out all their talks on the YouTube. I saw quite a few of them. Even before I came, I ever thought I would come for a seminar like this. But this collaboration, I think, is extremely important. But having said it, there is another part, mentoring. This is a profession which needs mentors. I'm sorry to tell you, this profession cannot survive without role models. I'm sorry, any other profession can, but the legal profession needs role models of teachers and lawyers who have stood up, who have had guts, who have actually had the courage to take positions in public life and said what they believed in. And unless you see them, and unless you rehearse their roles, even in the past, even today you must know, in England, they think of a Hartley Shawcross. Even now they think of somebody like Elvin Jones. Even now, they think of their past, because the past is so important for the purpose of current inspiration. And we must know that teachers who are law professors, then lawyers, they actually are the most fundamental sources of inspiration. Now, that mentoring cannot be supplied by a NAC. That mentoring cannot be supplied by a UGC. Now, if you look at that new bill, the bill which is presently under consideration, is a bill which I hope will see, hopefully, a premature demise. That bill actually has done an extraordinary thing. What it has done is it has said, well, this UGC, forget about the UGC. These are all professors, and you know, professors don't know very much in any case. So let's keep them out. Now, who should it consist of? We should have a search faculty. Who should the search faculty consist of? Well, there is a man who is the head of bureaucracy. So he is actually going to search what? Who is going to compose this commission? And who is the commission going to consist of? My word, actually, it boggles your imagination. 8 secretaries to the government of India. If you believe that 8 secretaries to the government of India have ever got through business, I promise you they haven't. And if they're going to get through education and legal education or any form of education as business on priority, you're completely mistaken. You know, Professor Ved Prakash, who was the chairman of the UGC, all that he could say from any address was what he was trying, what he was hoping, what he wanted, how quickly he wanted. I mean, you felt actually it was a desperate voice you could hear from him. Now, if you have this sort of a committee, what are they going to do? What are their rules? What are their criteria? And I think if you don't have defined values in education, and it's not that we're looking at some amorphous material from Mars, which we need to now analyze under a microscope. We have enough people who have done hard work on the field. We just need to put things together, and there has to be an act of self-affirmation. And I'm afraid, until anything happens, at least the idea in Gangtok that universities which believe in themselves of having maintained some minimal standards get together, and they actually force by peer pressure. Peer pressure is the best pressure at the moment educationally for an institution to see that only the good alone are admitted. Thank you.
Thank you, Mr. Subramaniam. And it's very good of you to highlight the importance of having a collective will to actually do something in the legal education space. I'd now like to call upon Director Gurpur, who's actually in the fight right now as we speak, managing Symbiosis Law School, to provide her thoughts on the current strengths and weaknesses of our Indian legal education. Director Gurpur.
Thank you, Professor. Thank you, the co-panelists and all the audience and organizers. It's a pleasure to address you from this panel. Much has been said by the two learned panelists already. One who has ideated the greatest possibility for legal education, and the other who had been in the helm of affairs regulating the quality of legal education as the chairperson of Bar Council of India. I'm afraid my perspective is going to be mixed perspective. First of all, as the on-ground kind of director of a leading law school in the private sector, so you can imagine the kind of trials and tribulations we could have been through. Second is sharing the forum with Raj and Professor Menon and Professor Chimney in Gangtok Declaration culmination way back in 2013, and many other experiences which I bring to the table. Now, current regulation, you know, in a way, has been there, and it is facilitating this diversity of law schools which exist in the country. Did they facilitate or they couldn't help? I can't tell you. As it was already told, 65% of the law schools are regulated by private sector. Now, most of the time today as well, and last evening as well, the discourses seem to be predominantly addressing the 25, to start with 3 or 4, and over a decade about 14, and currently about 25 national law schools, which are standalone law schools, and they are being hailed. Maybe because the legal education was put on a kind of quality pedestal, with discipline, with merit-based admission and professional training being seriously offered in terms of correlation between the skills required in the various hues and colors of the profession and the content of the curriculum and the process of training. However, the rich contribution of interdisciplinarity in Indian legal education in terms of its various outcomes, including the eminent lawyers, academics, and judges, cannot be ignored. And this rich contribution came from traditional universities. I'm so happy to state with you or share with you that I am a product of an interdisciplinary orientation, a science degree holder with the merit to join medical college. I rejected and came to law because of the family compulsion of having loads of property mired in litigation, and wealth was as if it was in the mirror. So I had to come to law by force, and I was inheritor of the land coming from the matrilineal community, and the men in the family were not able to come to the fore and talk because they were always lost in fights. So I joined the law school. Within 2 years, I was able to settle the entire dispute out of court, about 5 litigations. So it's possible, but it was possible because the scientific rationality was being taken to the level of legal education. And during education itself, I was able to master the techniques of dispute resolution. Now, it's not that I studied in any national law school or had any international exposure for postgraduate studies. I think interdisciplinarity is the context, and your own culture, your own reality is the context, which cannot be ignored in legal education. So, what I experienced as a law teacher and later as the administrator of this law school is that, as Dr. Menon pointed out, there are multiple masters for legal education, and latest master I am seeing in the trend in national law schools is the judiciary as the master. I mean, hitherto, judiciary was a kind of a protector, a kind of promoter. I can't understand the legitimacy that it can draw from which legal basis, because judiciary is supposed to be independent, and independence expects accountability as well. It expects a hermit-like kind of detachment, but I don't know from where it has merged out of which dream or vision, but that's the reality that I see, which I find is very, very dangerous for legal education, because of many reasons. This is not the forum to discuss all those details, but I would like to register this dissidence with the current trend. Second, autonomy, flexibility, and adaptability of legal education was challenged by the earlier legislations or earlier regulations, and that was facilitated by the 2008 rules. I mean, despite my difference with Bar Council, I had also joined hands with Bar Council after the post-2008 regulations, because it facilitated diversity of legal education. So let me tell you, the picture is not all that bad. There is a lot of optimism there, lot of space there for experimentation. I saw the possibility of 4 different kinds of law degree evolving out of the 2008 rules. And the full potential of this regulation was realized, it was visualized by an academic leader, Professor Mitra and his team. One of the products of Dr. Menon's first batch, Rahul and some of them came together. So when the academics led and synchronized various voices, culminating into a kind of standard, it did bring a lot of meaning. Now, quality legal education, when we talk about, that costs. As Raj already said, I need not re-emphasize it. Who shall pay for that quality? Today, if I'm talking about access, affordability, diversity, and innovation, which are the most hailed values in any higher education, and in legal education in particular, where do we get this money from? And then, should we compromise on delivery of quality legal education, or should we allow this kind of diversity in quality? I'm sorry to say this, we have a diversity in quality, which our 2010 BCI report itself acknowledges, the different kinds of law schools. Now, should we allow that kind of quality diversity at the expense of quality per se, is the question that we need to ask. The model curriculum which was given also was acknowledging this stratification in quality, and it had proposed certain changes. Now, these changes, how many law schools have adopted, we do not know. The strength in this curriculum was the diversity of courses, options, honors courses, elective courses, the choices which was given to students based on the capability of the law school, interdisciplinarity which was envisaged there, the audit which was envisaged in that rule, the inspection manual which was there. But what was missing was the recognition to research. And thereafter, when Mr. Gopala Subramaniam was chairing the council, there were very strict standards of legal education which were laid out. So I was making my management to go through those standards in conjunction with these broad rules. So we were able to do a lot of good. Matching 100% these standards meant it is top-class law school. On the other hand, UGC's terrain is very uncertain, because UGC puts law in social sciences and humanities. I mean, it has never acknowledged the professional position of law. Now, if you look at the multidisciplinary universities, it looks like an ideal possibility, but law is the poor cousin in multidisciplinary universities, because law is always seen as a cash cow. Lot of students, no regulation. The inspection committee which comes recommends certain things, and it doesn't insist on implementation. Of course, recently the picture has changed. What I mean to say is that the synergy between UGC's way of looking at legal curriculum and the Bar Council's way of presenting the curriculum is missing. And because law is seen as a neglected cousin, because of the strict implementation of compliances to these standards and rules, most of the law schools did not get their own good infrastructure for a very, very long time. Once the market showed the possibility, once there was a revenue potential possible, in some of the contexts, the standard of law schools improved. Now, looking at the global and national context, in globalizing India, with diverse careers which are to be catered to, practice readiness to be looked at, profundity of the product to be aimed at, we see that there is a standardization which needs to be looked at with the diversity of evolution being taken into account. There are Asian and other models, which earlier was discussed by Professor David and others. I would suggest that, as I would go by Carnegie Report's one standard, legal education to be almost aligning with the medical education model, with strict compliance to ethical guidelines, with a separate directorate, as Sir already told, and in the line of ICMR, Indian Council for Medical Research, Indian Council for Legal Research. In response to the next two questions, I'm going to share with you my other ideas, including a model for Indian Council for Legal Research, which emerged in a Gangtok Declaration and other deliberations. Thank you, Chair.
Thank you. So there were a number of issues raised in the opening comments, including many related to how do we maintain quality of educational institutions in India, how do we develop the collective will to actually do that as well as to propagate the legal profession in India. And of course, as part of that, if you're thinking about your regulators in India, you worry about who has the necessary expertise, who has the incentives to actually propose rules and enforce them in a way that would actually function. Maybe as a way to think about that, we can start by asking, there are so many standalone law schools now in India, and indeed standalone institutions, both on the medical side, the legal side, name it. How do we ensure quality there? As Professor Menon mentioned to begin with, right now 65% of the law colleges in India are not under a particular regulatory authority that seems to function. What would be some good steps to consider to bring that to bear? And maybe I'll start with Professor Menon to begin with. What do you think might be some good first steps to try to ensure quality, and who might we want to actually be staffing that decision?
I don't know perhaps the best thing is not to have any regulation at all. We have the constitution and we have the national education policy, then leave it to the standalone law universities to set their own standards, and let there be diversity. Why should there be a uniform curriculum and a uniform standard? It cannot be in a country like of India's size. But there are other models, as it was suggested. The Medical Council recently has come out with very strict standards for starting a new medical college, for admission of students and things like that. And we had an experience of about 4 medical colleges having been de-recognized by the Medical Council, still with the patronage of the state government, admitted the students, and 1.5 years through their studies, the Supreme Court intervened and de-recognized them, upholding the Medical Council's prescription. That is one model which could as well come if you consider legal education as professional education. If you consider legal education as general education, then leave it to the UGC and the universities concerned. That is the second model is what Gopal Subramaniam has mentioned, that was contained in the Madras High Court judgment of identifying those institutions out of these 1600 law colleges which would fulfill the minimum requirements for being a professional school, and then let the others come up to that standard to be admitted. That is what the essence of the Gangtok Declaration also. The Gangtok Declaration only said that let that accreditation process come to those leading law schools which have a responsibility, power with responsibility, which for many reasons an official national level body, whether it is Higher Education Commission or the UGC or the Bar Council, unable to do that of a country of India's size and dimension. So therefore, there are different models by which we will be able to redeem the situation, to improve the quality, and that's a continuing process, whether it is curriculum, faculty recruitment, infrastructure development, things like that. You need to look at each level by concerned stakeholders, who primarily the law students and the law teachers. They are the real people who are going to build the future standards of legal education. So therefore, this responsibility should come back to them, and teachers should be responsible if failure or mistakes happen.
Thank you. Director Gurpur, you would be one of the people that would have that responsibility, as Professor Menon suggested. What do you think might be some things we can do to maintain quality? Of course. No problem.
What I look at is what they have mentioned now, the separate comprehensive directorate, but I would say all stakeholders should be represented there. I don't think lawyers and judges and the teachers have any kind of hierarchy among them. All of us are equally passionate stakeholders about legal education. In no way there is a justification for a hierarchical model. So I say that should be a flat team structure, and rotating, the head should be rotating between these stakeholders, and then preferentially academic credentials have to be taken into consideration along with experience. Second thing I suggest is there should be a separate taxonomy of legal education. This I have been arguing even in the international fora. We can't take average or generic higher education taxonomy for legal education, because we are in the business of defending rights. We are in the business of structuring governance and arguing, dissenting. So our training process, our educational process need to be separately, scientifically developed. There should be a rich menu of choices to the student, because I believe in student-centric legal education, because they are the future and they are to be protected, they are to be satisfied. So there has to be intersectionality between disciplines in research, and there has to be research in intrasectionality within the law. So I advise in our university, we are developing a behavioral lab for rule of law. Why there is a compliance or non-compliance to rule of law? The basic problem in post-colonial societies is deviation from rule of law. Why is it happening? How is it happening? To what extent it's happening? So we have a behavioral lab coming up in our management science. So I was trying to tap on that. So this year onwards, our whole series of research is going to be on rule of law in context. Now, another advice I have is 85% of the focus in terms of student profoundness should be on soft skills, which was told earlier, including experiential learning in terms of application context of law, learning from other professions. So I'll mention other things when I come back to what kind of change we require in response to your third question. Thank you.
Thank you. So it's interesting, both you and Professor Menon have mentioned that it would be nice to have a menu of options, a lot of differing levels of quality potentially. Mr. Subramaniam, having been the president of the Bar Council, that would be something that you would then have to face. How might one try to maintain quality while still allowing for a diversity of approaches?
I think actually I don't see a conundrum there. I think what's important is quality negotiable? We have to answer that question. We have to address that question. If quality is non-negotiable, the rest will follow. And I think on quality, there must be certain agreed parameters. And I don't see why we cannot have agreed parameters as far as quality is concerned. I see the point which has been mentioned by all the other panelists, and it's correct, that we are a huge country. We have, shall we say, differences in different states. We have different social conditions that can never be actually digressed from. We have conditions even which are barriers in terms of language, and that also must be addressed. But even, I think, notwithstanding, and that's an example, notwithstanding different languages, different states, it is possible still to have what I believe as common denominators. But I think there's a point I wish to make. The importance of common denominators is this. A law student becomes a lawyer, and I want him actually, I hope that they have to go through an exam at some point of time. But even if he succeeds in that exam, he is going to affect people's lives by his conduct and the decisions and the advice which he gives. So it is analogous, shall we say, as was said, to the medical profession, as Professor Menon said. You are playing with people's lives when you are a lawyer. And you're also playing with the lives in society in a larger sense by your own attitude, by your own fundamental construct. So the fundamental construct, I guess, of a law student has to be properly nurtured. And there Professor Menon is right. The ball is actually in our court. Why are we looking at regulators as some sort of heavenly angels or heavenly interpositions? Ultimately, we ourselves, within our own compass of universe, of students and teachers, have to set it right and make it absolutely rigorous. The second point about menu of choices, it's an excellent point. It's a very valid point. I still remember when the professor was there as the head of Symbiosis Noida, and she came at that time when I was chairman of the Bar Council to tell me what kinds of problems she was actually facing, and I couldn't believe that for somebody who had established an institution, who had a menu of choices, she was undergoing somewhat absolutely unfortunate difficulties in getting through with recognition. And the menu of choices is indeed a very valid point. Intersectionality is an extremely valid point. I think in some sense it also eases up on the legal profession being the sole source of revenue making for law students. It opens up other avenues. It is something which again David has touched in his many of his articles when he talks about it, because somewhere he takes law closer to governance, policy making, politics. In fact, politics. I think politics is somewhere one should really think that it's necessary for people to have a very good orientation of law, because they often make law. And I think it can touch upon a multiplicity of disciplines. And today we have a situation where, and that's again a very valid point made, where I think the people who are in let us say the most backward regions are entitled to the best quality of access to justice. Why not? I think it is perfectly possible. It is not that they don't have talent. I want to demonstrate it with a personal experience of mine. I had a case, a gentleman who was, he was accused, he was actually being tried in a trial court in Jharkhand. And it was in Dumka, which is a backward district, and mostly the predominant population is tribals. Many of them are Christians. This was a lawyer who was a tribal lawyer, and he brought his entire case file, and I saw how he maintained his case docket, which included all the note sheets, the case law, the way he had ordered his thoughts, the questions likely to be posed by a judge. Well, he was faltering in English, but the way he arranged his case docket made me feel so humble that here was a man. I said, where did you actually do your law from? He said, sir, I did it in Dumka. I said, you mean it was at, he said it was after my BA honors. I did a 3-year course and I'm a lawyer. I said, how many years have you practiced? 3 years. But there was a sense of fastidiousness and fidelity to the client. Now, this is the second point, that fidelity and loyalty to a cause or a client and to the profession has to be inculcated by the institution and the teachers. The menu of choices is actually where aptitudinally, and that's where I was talking to the dean, that psychometric inputs are very important. Aptitudinal inputs are very important because they then allow the person to navigate with law with a correspondent field which will give credits, which will also enable the person to blossom. There's one thing which I always believe in. That's my personal belief, and I am not asking anyone else to subscribe to that belief. Knowledge has a quality about it. It is like, I'm not saying it's a black hole, but it has a quality. You get started in any stream of knowledge at any point. But if you are true to it, you pursue it with a certain passion, you are bound to land up in many other streams, and they would have enveloped you, caressed you because of the sheer overpoweringness of your passion. And that is something which law schools, you know what law schools are? They should be the greatest centers of energy. They are the ones, as Professor Menon said, are going to deal with possibly the most important common components of our society. And today we have this great, because of this wonderful seminar, we have this great openness, and we have this great, shall we say, enlightening possibilities of exchange, of, shall we say, interfaces with other universities, illustrious people. So today, nothing is far away. So there is nothing called international anymore. The international has actually come to us. We are today truly international. But it is now for us to take advantage of their presence, their willingness, and their gesture, generosity, and actually work together to make this a real possibility. And personally, with somebody like Sashikala there, somebody like Raj here, I don't see why it can't be a possibility. We're very close to it.
Thank you, Mr. Subramaniam. I know that Professor Menon has to leave soon, so I'll ask him the final question that we have on our list, which is, given all the issues that the legal profession is facing, whether it be technology, globalization, many other challenges, what do you think would be some critical reforms that we might need to make? Maybe just two of them to start that might be digestible for the audience.
I think the most important reform that higher education in general and legal education in particular needs is complete academic autonomy to decide as to what is the mission of your institution, how it needs to be structured, what the sort of curriculum and syllabi need to be organized for that, the pedagogy that you will use. That academic autonomy is the key for any quality improvement, which cannot be guaranteed by any regulator outside the law school. That is perhaps one reason why law schools in America could prosper, that they have the complete autonomy to decide what they teach, how they teach, and how they evaluate and things like that. Nobody to tell them. That sort of an autonomy is absolutely necessary. I am not very particular with respect to the financial autonomy or the administrative autonomy, which will naturally come if you are assured of the academic quality, which is something which need to be addressed seriously by teachers primarily and the management of the institutions concerned. I believe that this is likely to come. I happen to be a member of a committee appointed by the previous federal government, the ESPAL committee, which was concerned with the rejuvenation of higher education in India. And the key recommendation is autonomy, and more autonomy. In fact, ESPAL has pointed out that many of the ills can be put, that lack of autonomy, unnecessary interference from external forces, be it the UGC or the Medical Council or the Bar Council. Therefore, you set the agenda in the national policy and leave it to the institutions to develop. And though there are arguments on the part of those who want a uniform curriculum to be followed in legal education, I do not believe that it is necessary, because the multiple jobs for which legally trained persons are to involve themselves for the larger goals of rule of law, democracy, human rights, good governance, not merely dispute settlement. If you were to look at that broader objectives of a good quality legal education, then you have to think differently than the mindset that Bar Council had when it framed the curriculum, or the UGC had, or many of the national law schools had when they went in for a single faculty university. I think we need to, and this will come, the pressure or the driver will be technology, the driver will be globalization, the driver will be economic empowerment of the people with liberalization. These inevitable forces in society, along with the constitutional mandate, will make higher education institutions given the autonomy to come up with a curriculum which is relevant for the 21st century, which will serve the legal services needs of the society, and which will fulfill those objectives which are reflected not only in the Constitution of India, in the Constitution of most countries, the UN documents, etc. That goals which we have set to ourselves at the end of Second World War, that can be captured by an individual institution with its mission with its vision, and the teachers and the students can execute it, it's a responsible job. Giving it to some regulator is power without responsibility, which will spoil the situation. That's my humble submission. Thank you.
Thank you, Professor Menon. And please join me in thanking Professor Menon for joining us today.